Good morning and welcome everyone to our New Hampshire Business Review webinar on business surveillance from a legal perspective. Today's webinar is sponsored by Shaheen and Gordon, attorneys at law. I'm Ernesto Burden. I'm the publisher of New Hampshire Business Review. And today it is my pleasure to welcome Michael J. Atkins to the screen. Michael, welcome.
Good morning, Ernesto. Nice to be here.
Good morning to you. It's worth noting you're live from a remote location where you just were presenting on a completely different topic just a few minutes ago.
Correct. I'm at the New Hampshire Institute of Politics, and it looks like the White House could be listening to us today. So we'll figure that out.
Exactly. So we are here to talk about business surveillance from a legal perspective. Just a few things about business surveillance in general that I think are really interesting and worth contemplating at the moment. One being that this has sort of been the year of talking about AI. AI has been prevalent in technology for some time now, but this year it seems like it became top of mind for even non-technologists. And AI, in terms of video surveillance in particular, is really changing the game. One camera manufacturer, a company called Pelco, says AI vision solutions, or computer vision as it's known in the machine learning field, uses highly sophisticated type of artificial intelligence known as convolutional neural networks. These networks analyze images looking for patterns that correspond to generalized concepts such as people or vehicles. The more examples a network is given, the better it becomes at identifying these concepts quickly and accurately, which means this technology is set to become even more advanced in the near future. And this is being used across all kinds of industries, from standard security type usages to healthcare, where even patient care is being monitored by AI video. That the processors can analyze so much data that would typically not that nobody would have gone through in the past, and make find patterns and make decisions based on that it's really quite a revolution. With all that said, and with all that happening, we're including some other, I think, really relevant changes within the workplace, most specifically the move to remote and hybrid working, which has certainly changed the kind of security that people are including in their business surveillance systems. The question that we're left with is, what does this mean for individuals' privacy, for their expectations of privacy? And at that point, I'm going to wrap up my very brief and top level look at some of the technology issues and dive into what we really came here to talk about, which is starting, I think, with an individual's interest in privacy, in the workplace, outside the workplace, when they're walking down the street, when they're neighbors. What do we expect?
Yeah, very good question. And I think because of the new technology, and this is evolving, and remember, the laws follow the technology, meaning this technology exists and then new rules need to be created to protect the concept of the protection of the right of privacy. That's why all the laws, whether they're state, federal, or international, is what is the right, particularly in New Hampshire, what rights to privacy do individuals have? And it's very clear that an individual in New Hampshire has the right to be let alone, and that our law protects it. Well, what does that mean? Is it just, when can I be left alone, and how can I be left alone? Well, there's 4 components to that in New Hampshire. Person is free to from intrusion upon their physical and mental solitude or seclusion. There should be free from the public disclosure of private facts. Free from publicity, which places that person in a false light in the public eye, and appropriation of a person's name or likeness for the benefit of another. And that last one, that right of privacy, people may become now be more familiar with the concept of name, image, and likeness that you've seen in college and athletics. Well, that is that fundamental right to privacy. That is taking someone's name, it's a business name or a person's name, and using it for their own commercial interest. That's not okay. And they each have different elements to, even though they're all under that umbrella of invasion of privacy, they have different elements. For example, free to from intrusion upon one's physical and mental solitude. You have you don't need to have publicity. It doesn't need to be published. The fact that someone would simply do that and invade that space, and no falsity is required for that, as opposed to the disclosure of private facts. No falsity is required, but obviously publication or publicity. What does that mean? I told one person. Is that actionable? Maybe. If you told more people, more likely to be actionable. Again, false light and appropriation have different elements. So it's, I think it's a really good question, because these are things that I think New Hampshire businesses should be thinking about when they're either auditing existing surveillance in the workplace or looking to add. Well, what rights? Because common sense sometimes isn't too common, but why do these laws exist? So you can think about that when you make those decisions. And there's different damages that each of those four elements. And I think one of the things that's important, and this gets into the employment context, is if you invade someone's privacy and they have a cause of action because of that, you don't even actually have to prove that damages were sustained. If you can prove that they were, those are likewise recoverable. But New Hampshire law protects just simply the right, and in and of itself could be actionable.
Michael, just two quick questions on the points that you made so far. Within the realm of public disclosure of private facts, what determines whether a fact is a private fact?
Right. The answer to that is, would a reasonable person find that to offend? And who determines that? The finder of fact, whether it's a judge or a jury. So it's not a simple definition. It's just, geez, 12 people in a jury box. If someone said that about me, would I find that offensive? That hypothetical reasonable person.
Okay. And then with the publicity, which places the person in a false light in the public eye, you mentioned that doesn't have to be like that. You didn't publish it necessarily or put it on television. It could just be something that is exposing somebody in a false light. I guess my question there is, what does publicity mean?
Yeah, and falsity and the false light does actually require the publication. And are you talking about specifically like an example of false light or
an example of publicity, I guess?
Yeah, and that goes to, and what New Hampshire law would talk about is, who did you tell? When we think of publicity, you put it in a newspaper. You wrote, it was on television, you put it on the radio, but it's much less than that. That is, and to put it in the workplace context, if someone were to overhear or by surveillance or otherwise, a private fact about someone, and then published it, told one person, told two people, told a group of people, and again, that's publication. It isn't just in the media. That can be actionable simply by telling a coworker.
So maybe can we use that as a opportunity to drill down a little bit? How would that be treated in the context of, let's say, a company has a surveillance system, both external and internal, and whoever's managing or monitoring that is shares information they've seen on that about an employee with, say, other managers or with that. I mean, at some point, doesn't all that have to be done for the surveillance system to be useful?
It depends. So let's take, for example, that there were surveillance cameras at a business in the parking lot.
Yep.
And it makes sense. It's a good place to have surveillance because things can happen on your property that you could be liable for after hours. It provides security for your business. And employees coming and going. If employees are just simply coming and going, not a problem. If employees are engaging in behavior that is illegal or contrary to workplace rules, and whoever's monitoring that surveillance, that would be an appropriate circumstance to disclose. If the same situation has nothing to do with work and met someone in a private relationship or something that has not work related at all, and now that being disclosed, now where are you in regard to the line of that person's right to privacy? Even though you are an employee, employer does not have unfettered rights over that employee's privacy.
So that's a very interesting situation as a specific situation. Does it change the expectation of privacy? Does the expectation of privacy have any impact on the right to privacy? So if I haven't posted a sign that says I have a camera, I think I do have to post a sign, right? If I have a camera,
it would be yes, it'd definitely be advisable.
Right, but if I have posted a sign, is there an expectation of privacy at that point?
And again, we're talking in the workplace context. Yes. The employees still retain an expectation of privacy, even in the workplace. And if there's a camera, the time, manner, and method of surveillance really should kind of govern some of the decisions that businesses would make. For example, we talked about cameras in a parking lot. What about internal cameras? Well, certainly, and the law is very clear and understandable, you have an expectation of privacy in a restroom or in a locker room or changing room that could be different expectation of privacy from the cafeteria, common workplace areas, hallways. What happens if it's in individual offices? And again, we're just talking cameras. And again, you can have different levels of expectation of privacy depending on where you are, even in the workplace.
Okay. So that, I think, leads to the question of what are some elements of invasion of privacy claims?
I'm sorry.
Elements of invasion of privacy claims here in New Hampshire, in particular.
Sure.
The different kinds of claims that people are
right
seeing.
Yep. And so again, the right to be free from intrusion upon someone's physical or mental solitude or seclusion, that invasion for intrusion needs to be something that is secret, secluded, private. How do you define that? That gets us to the reasonable person would find offensive, would believe that to be private. And just invading someone's space, you don't need to have publicity or publication, which publication meaning telling someone else. The disclosure for the public disclosure of private facts. Again, something secret, secluded, or private related to that person that does need to be published. And again, not media, I'm talking simply communicated to someone else in whatever manner and method. And it doesn't matter whether the information you did was true or false. It could even be true, but if you disclose something of someone private that fits the category of a secret or private fact, there could be liability. And false light, placing someone in a false light, does require falsity. So again, this concept of the right to privacy is multi-pronged.
Right. And what about the appropriation side?
Well, in the appropriation side, I think there's a number of examples. We talked about the name, image, and likeness, and just think about that, right? Because what that now we know name, image, likeness, whereas we didn't before. In that situation, again, in college athletics, you had athletes who are amateurs not being paid, receiving payment, but there was actually the electronic football game really started all of this, and the electronic video games, because they would take college players, literally use their name, image, and likeness, and generated lots of money. None of the players got anything. Well, that didn't seem fair. And so if I wanted to advertise myself as Ernesto Burden and come to watch my webinar, and you didn't have anything to do with it, you didn't know, that's very clear that makes sense. That isn't fair. And so those are some examples, and you see it a lot in knockoffs, in businesses and knockoffs, right? Whether it's a knockoff product of a brand name would be an example of that, or trying to associate yourself or present yourself to the public of having association with a particular business when you don't.
Right. Well, you've given me a great idea for a webinar series in which I license my likeness to somebody else, maybe an AI, and we could triple the number of webinars we're doing. So one of the things that we had talked about ahead of time was what are some of the damages recoverable for invasion of privacy, and then and I do want to mention from there we're going to jump into privacy in the workplace specifically after we've sort of laid this foundation. But I also wanted to mention to the audience that please feel free to chime in the Q&A. If you type your questions in, we'll answer them as they come in or as they fit into the flow of the conversation. And I do have some questions that were submitted ahead of time, so I'll also be bringing those up as we get to that part of the conversation.
Great. And so the damages, and we talked a little bit about this, in New Hampshire, Live Free or Die in particular, we take that right of privacy very seriously. Other states have different rules. In New Hampshire, for damages, just simply the fact that your right to privacy was violated, you could have a viable claim and recover damages. The difference between nominal damages, okay, yeah, I violated your privacy, here's $10, versus what other damages are recoverable. And again, this will go to the employment situation, because the same context remains. If in New Hampshire, if you violate someone's right to privacy, you could be liable for mental distress if it's proven and is the kind normally that you would associate with an invasion of privacy. Special damages caused by invasion, what would that mean? So if someone literally physically penetrated a residence or a workplace and put a camera in and did other damage physically that you had to remedy as a result of that violation, that would be something that would be recoverable. If you sustained a physical harm as a result of the invasion, that would be compensable. And so again, mental distress, unjust enrichment. So when I started my AI Ernesto webinars, and I got a big pool of money using your name and likeness and obtaining it, well, I was unjustly enriched. So I'd be required to disgorge, if you will. And any harm that I caused, because I'm certain I couldn't do it as well as you, to your commercial interest, because I was out there claiming to be affiliated or the like. So you may have sustained damage as a result of these not so well done webinars that I did using your name.
Okay. How you had mentioned here in New Hampshire, invasion of privacy is taken very seriously, and therefore the damages are likewise. Is there a great deal of variance in state laws?
Yeah, the answer is no. And I think the majority rule or majority states have the same types of claims. I think in New Hampshire, it's just been emphasized, and we've taken great pride throughout our history of that independence. And you can just see it in New Hampshire Supreme Court decisions today. They just continue to state some of the bedrock principles of freedom, liberty. We won't even look to the United States Constitution if I can answer under the New Hampshire Constitution first. But other states have similar thresholds, if you will, for viable claims.
Are there federal laws that are also applicable?
There are, and particularly in the workplace setting. The biggest federal law is what's the Electronic Communications Privacy Act, or ECPA, and its amendment, which is the Store Communications Act. And that federal statute and amendment is to protect the privacy of electronic communications that are text messages, email, stored data, including some unauthorized access by employers. That seems to be the predominant federal law, and there are exceptions to that, right? Even for an employer, if they could show legitimate business purpose in regard to their monitoring of these electronic communications, or an important issue that we'll talk about, if employee consents.
So that's should we jump into that now? I think we're truly in the workplace now, with the discussion of that, the Electronic Communications Privacy Act. How can employers lawfully monitor employees, and how and where did they cross the line? And maybe, if you're talking about electronic communications, things like email, keystroke loggers, things like that. Yeah.
And again, another example of technology getting ahead of the law, and we know what's coming. But that privacy in the workplace, as you correctly say, an employer can generally monitor employees in their workplace. That being said, there's a labyrinth of laws that could be applicable, and I'm going to try to hopefully provide some practical overview for New Hampshire business folks who are listening or maybe listening subsequent. I think the biggest state law in regard to this is New Hampshire's privacy law, which prohibits surveillance in any private place, non-consensual surveillance in a private place. And we talked about time, manner, method before. Well, what's a private place? A private place per New Hampshire law is where one may reasonably expect to be safe from surveillance, i.e. a public restroom, a locker room, an interior of one's dwelling, any place where anyone's private parts could be exposed. That's what New Hampshire law defines, and it's a criminal offense in addition to potential civil liability for activity that violated that. It's a criminal with a Class A misdemeanor. And I think because privacy is continuing to become such a significant issue, there's an amendment to the New Hampshire privacy statute that goes into effect in January of 2024, that a second or subsequent offense of violating this could go from a Class A misdemeanor to a Class B felony. Because I think the legislature, and understandable, and I presume other states around the country, are trying for there to be significant consequence, because there is a difference between invasion of privacy with a peeping Tom, if you will, and now the tools available in regard to electronics and the lack of privacy. And also, this is very important, the New Hampshire wiretap law. And of course, there's federal wiretap laws. And that is, it's important that people understand that New Hampshire is a two-person consent state. And what that means is everyone in the conversation, if it's being recorded, particularly audio, has to consent before that can be done. A lot of states are only one person. That's why we've heard over the last 4 or 5 years, some of these taped conversations, we learned that New York State was a one-person consent, not in New Hampshire, and it's a criminal offense. So if you're an employer and you have video, you need to really be concerned of, do you have audio also? And if you do, what consents do you have? Because you don't want to end up in a situation where you not only have claims by employees or potential vendors, but there's criminal liability as well.
So would that include a situation, where a sales organization monitors the phone calls of their sales representatives? Are they always, when they onboard new staff, including consent as part of the onboarding?
Yeah, very good question. And the answer to that is yes. Because, and I would suggest this for all New Hampshire business people, whether it's a sales monitoring phone calls, we're all very familiar with this call will be monitored for quality assurance, right, that we hear. When you're onboarding, particularly employees, and this goes to your policies and procedures of your business. What do you have in there in regard to surveillance? What are the rules of the road that your business has put together? And disclosure, notice, consent. Those are the types of actions that employers should be taking to prevent any potential claim. So having an employee sign their employee handbook, recognizing that there is surveillance at the workplace. This is what it is. This is where it is. And we may be doing more. Having that person have a signed consent, I would suggest, very important.
Would that be the same for keystroke logging or things like that with email, even though it's not recorded conversation?
Yes. And so say, for example, and a lot of employers understandably have this, we don't want our employees out surfing the internet on Amazon and maybe some other sites that we prefer they not be on during work hours, at least in your workplace. Well, how do you monitor that if you don't have access to that? So I think that's a very important and practical concern for New Hampshire businesses. And that absolutely should be included in the consent.
Okay. Do you have a sense of how many New Hampshire businesses, sort of what the depth of surveillance practices are from business to business?
My sense, and my review of both this topic and obviously having clients with related issues, I think we're well over 70-75% or more. Particularly just simple, if you will, surveillance camera outside parking lot to protect the physical integrity of the building. And at the time, it would just, you're thinking, well, this is real simple. This is my property. I'm putting this camera over here because I don't want people to break in. But since that rudimentary technology, and it's more and more inside the workplace as well. And certainly the access to emails, the access to being able to check a web browser history if need be.
Yeah. Well, this certainly, it seems like some of the technology advances, both in terms of the reduction of the cost of camera systems, the ability to go through the data that the cameras collect more efficiently, especially with AI, means that there are more in use by more people, and including things like nanny cams, Actually, that's a good one to throw out there. And then I want to bring up a question from the audience that was submitted in advance because it's also related to this cameras. But if you hire a babysitter and you have a camera in the house hidden inside the teddy bear or whatever people do, do you have to have that? Does the babysitter have to consent to that?
I think that certainly legally, the safest answer to that is yes. But then again, is it video only? Is it video and audio? And clearly, it can't be audio without that person's consent. I think if you had the camera in your house for this babysitter nanny cam situation, again, providing notice that we do have cameras in the house would actually serve a purpose of deterrence. But also, I think it's the safest and most appropriate legally to do as well.
Okay, and then I guess the next logical question would be, does that also apply to things like the Ring doorbell camera? Do you need a sign on your house if you've got one of those?
Arguably, yes. And there's talk about ubiquitous. The cameras everywhere, and it's just so easy for people to have access and Ring doorbells. I actually just recently had a case involving this very issue. And the court found that it was fine and appropriate. Would a different superior court judge find that to be different? And if you have a Ring doorbell, that's one thing. If you have cameras on the outside of your house, where are they pointing? Where is that video feed going? Is it being retained? Because it's one thing to have a camera on the exterior of your home or workplace for the purposes of protection and security. It's a different if that same camera is now turned towards your neighbor, property, or inside their house.
Perfect segue to this question. This is a question that was submitted by somebody who manages several communities, a property manager. And she writes, can an owner refuse to allow a tenant to attach surveillance cameras and Ring doorbells to the exterior of a building? Can tenants point cameras at neighbors? I manage 2 communities, a total of 90 units, and we have had several issues regarding surveillance and privacy.
Yeah, really good question, and thank you for that. I think let's start at the beginning of that relationship, being the landlord-tenant. Even if it's a property manager, obviously you're dealing with the tenants on behalf of the owner. What do the lease agreements between the landlord and the tenant provide in this regard? And that's the best way to address it. And if the property manager or landlord wants to specifically limit or prohibit that type of activity, it's something that they really should be thinking about putting in their lease. In regard to legally, it's where is it pointing? We get back to the Ring doorbell or the camera pointing. My sense is, having been involved in a number of cases related to those situations, is that it's probably a tenant who's maybe not the least lowest maintenance tenant, and they're trying to find wrong. They're trying to get the landlord in trouble. They're trying to, and I'm not diminishing anyone who just simply wanted to see who was coming up to their door with a Ring doorbell. But I wouldn't be surprised if the background of that question dealt with something more intrusive.
Well, it did sound like can tenants point cameras at neighbors? So I'm picturing one of those situations where they want to catch, they're insisting that the neighbor is outside making noise at all hours of the night, and they want to catch them on the camera and do something, or somehow make a point.
Yeah, and the answer to that is no. I think that I think the landlord arguably has some legal liability if it's allowed. And certainly the neighbor, who have we invaded their privacy?
Yeah.
Where is it pointing? What was the expectation of privacy depending on where this tenant in this situation was pointing the camera at the neighbor? Is it at their front door to see if they came and took their used to be delivered newspaper to the front porch, or are they pointing it into their dwelling?
That if a camera catches the interior of a dwelling, because I know you mentioned earlier that you know that a place where you had an expectation of privacy was a private place, and that was the interior of one's dwelling. If you have your curtains open and somebody has a camera that captures your living room, even if you opened the curtains, is that still a place where you have an expectation of privacy from a legal standpoint?
The answer is yes. And that would be a situation of, well, if your expectation of privacy granted existed, is it now lowered because you opened up your curtains? And if someone moved a curtain, or, you know, outside there was the curtains were closed, but there was a little gap, and now the person, you know, you can see the heightened expectation of privacy. But the premise is absolutely, even looking in people's windows, not okay. You have that expectation of privacy in your house, and you don't lose that by having a window.
It makes me curious as to whether there were ever any cases around the Google Street View project where Google drove around with cameras on top of the cars, taking pictures of all the houses. They must have captured plenty of open windows.
Yeah, and I'm unaware if there are, but it is this concept of privacy. It comes back to, I don't know about you or some of the viewers, but the first time that I became aware of that technology and using it, which I use all the time now, and I said, oh my God, there's my house. Oh my God, you can see everything in my backyard. It's really the sense of invasion, that someone could literally be looking down from outer space and taking pictures of our backyard.
Yes, and that imagery has all improved tremendously.
Yes.
So it gets scarier and scarier. We have a couple of questions from the audience. Thank you, folks. The first one is, are there restrictions on having a camera that only turns on when an alarm is set off within a business space? Or I guess maybe an alternate way to think about that would be, are there fewer restrictions on cameras that only go on when something specific happens?
Okay. So and this is a business setting, as I understood
Yes.
the question.
Yeah.
It sounded like motion activated, or siren activated in this situation. I think that would be hard pressed to someone to say that you're doing something wrong if it's only activated upon an emergency. A siren means something happened, and having it tied into that system, I think that's again certainly legal. And again, what is it filming? Where is it filming? When that siren goes off? But I think that's totally appropriate.
Okay, and then related, I think cameras get everybody thinking, right?
Right.
How are dash cams handled? I've had questions about a dash cam in a vehicle left on while a garage does work. How should that be handled for video captured outside the vehicle and inside the vehicle? Is there a difference if the video points inside the vehicle versus outside the vehicle?
Look at this technology. Could you imagine? I'm taking my car to get work done and filming people, right? Certainly you could have a camera and a dash camera. I go back to, is it video only or is it audio? If it's audio and it's in the state of New Hampshire and you do not have the consent of anyone's audio that picks up, it's not only contrary to New Hampshire law, it could be a crime. In regard to just the video, again, is it pointing only inside is one thing. And I wouldn't think you'd have a sign inside your car saying, hey, people working on it, I have a camera, be nice to me. But certainly if it's not something that's hidden, a camera in the car and they could see it, I think that they would be okay.
Okay, great. Well, this conversation has flown by. We had planned to talk for 45 minutes, and we have about 5 minutes left, and I think still some interesting things to cover. So let's certainly. Oh wait, we've got one more follow-up question on the dash cam, and
Yes.
then I wanted to get to you had talked about considerations for New Hampshire employer in regard to how and if surveillance should be used in the workplace.
Yeah.
And I think you have a little bit of a checklist that you can walk through. But before we go to that, we have a follow-up question on the dash cam. Is leaving a dash cam on while you are away from a vehicle in order to catch ongoing vandalism a problem?
No. Is the short answer. And again, I think that's a security issue, and I think that's okay. No audio.
No audio. There you go. So just video always okay in that context.
In that context.
Okay, so what are some things that employers should do if they're considering using surveillance, or think about if they have a surveillance program but they haven't necessarily vetted it through a legal consultant?
Yeah. I think one of the things that I hopefully that we've been able to capture this today, because this is a topic that is so large and so fact specific in a lot of instances, to try to bring some practical help to New Hampshire businesses who either have surveillance or are thinking about having surveillance. And the way that I look at it is, first of all, you certainly should be take an inventory or audit. Do you already have some? Why do you have it? Is it being effective for you? If you're looking to add to existing or start, why are you doing it? If you already have it, has it been helpful? Has it served its purpose? And one of the bigger things in whatever surveillance that New Hampshire businesses decide to implement in accord with notice and consent, ideally, what is the benefit of that? And is there any concern that, first of all, it needs to be narrowly tailored to that legitimate business interest, security of your building, preventing theft? That's a legitimate interest. So you don't have a camera that covers this much. It only needs to cover. And also providing that notice and consent. But the other thing to think about, we could have all kinds of technology. The keystroke that you talked about, AI coming next, is what's the benefit? What's the downside? How is this affecting your employees? What effect does it have on their morale? What effect does it have on team building? And don't do more than you need to. And just from a business consideration, is it helping productivity? If you're adding, how is that? Because the effect on the employees is something that I think that should be considered. And updating your policies, making sure that they're signed and consented to. If you have existing employees and you didn't have surveillance, but then add it, amend your policy so that everyone knows. That's the biggest thing. Notice, consent, visibility, signage, making sure that it's noticed everywhere. Where's it located? Making sure it's not capturing audio. And because what's the court going to do? You now have an employee who feels that their privacy's been invaded. They've sued you for wrongful termination, or they sued you for invasion of privacy. No one wants that as a business employer. You want to protect your business, but you're not looking to have that, because what is a court going to do? It's going to weigh, where did this happen? How did it happen? Why was the employer doing it? Versus those fundamental rights that we talked about in the beginning. And as you go forward with the biometric face imaging and artificial intelligence, the laws aren't in place yet because that technology isn't rolled out, but it's coming. So again, I hope that we've been able to provide some practical and helpful information. Certain my email will be made available. If anyone has additional questions after this, I'd be happy to speak with them.
That's wonderful. Well, thank you. Yeah, it is such a thought-provoking topic, and I am sure that we're going to want to revisit this. So I hope that you come back. And I'd like to thank everybody who joined us today. I'd like to thank Shaheen and Gordon for sponsoring this webinar, and of course, thank you, Michael. This was fantastic.
Thank you.
We look forward to talking again. And in the meantime,
Yes.
I hope that everybody has a wonderful day.
Thanks.